Mr. Speaker, none of it makes sense. Not the collapsed trial, not the Chagos, not the embassy. But as my right honourable friend, the member for New Forest East says, it all makes sense if the government has prioritised a strategic relationship with Communist China, doesn't it?
Yeah. Solicitor General.
Well, I'll politely remind the honourable gentleman that this case was to be tried under the government's position in relation to China between 2021 and 2023, when, of course, it was his party that was in government.
Nick Timothy.
Thank you, Mr. Speaker. Although, to be perfectly honest, I don't know what the point is, because we've had 2 weeks of statements and urgent questions, and ministers keep coming, attacking straw men and answering questions that aren't actually being asked. It's pathetic. On Monday, the Security Minister came to the House and was asked several times when the Home Secretary knew that the case was going to collapse and what representations she made to ensure that the case was as strong as possible. He didn't answer that several times. So when did the Home Secretary know? What representations did she make, and to whom did she make them? Surely among them was the National Security Advisor, the Prime Minister and the Attorney General.
I don't speak on behalf of the Home Secretary, but I'm sure that she will be happy to address the honourable member's points.
Justice Secretary of State Robert Jenrick.
Thank you, Mr. Speaker. Let me cut to the chase. It's standard practice for the CPS to inform the Attorney General if a case of political significance that had required Attorney General consent in the first place was likely to be dropped. We're told that the Attorney General was informed this case was at risk, but the case had not formally been ended in August. Is this correct? Can the Solicitor General provide the exact date of that meeting? It would have been his duty to ask why it was at risk. That does not mean seeking to change the independent judgment of the CPS on whether to proceed, but it could and should have meant asking and ensuring more evidence was provided to the CPS at their request. It was abundantly clear that the CPS were asking for further evidence on the question of whether China posed a current threat to national security. So the Attorney General and the government had a decision to make, whether to provide the evidence or not, even if they thought it was excessive to do so. The Attorney General must have understood what was required. We are told he is an eminent lawyer. So what did he do the moment he knew? Who did he inform within government and when? Did he inform the Prime Minister or his office? Did he take any steps to ensure the evidence was provided? We know that on the 1st of September, the Director General of the AG's office attended a meeting at which the case was discussed. At this point, the case could still have been salvaged. At that meeting, did the Attorney General's office push for further evidence to be provided? Following that meeting, the Sunday Times has reported that the Attorney General's office was asked to speak to the CPS. Can the SG confirm whether anyone from the AGO spoke directly or indirectly to the CPS? Mr. Speaker, the AG knew the case was going to collapse in August. He knew what was required to save it. But unless she can provide a compelling account today, we must all conclude that the AG, on behalf of the government, chose not to provide it. He may not have killed the case, but he allowed it to die. There are examples in the recent past of AGs having the candour to come to the House and explain that the government and the prosecuting authorities have chosen to drop cases of the highest national security questions for diplomatic reasons. Will the SG today have the candour to do exactly the same with this case?
Today we've heard from the Shadow Justice Secretary yet more of the baseless smears which have characterised the Conservative Party's approach to this matter of such importance to this House and the whole nation. And he knows that the Attorney General will be giving evidence next week, as soon as Tuesday, to the Joint Committee on National Security Strategy. Like me, the Shadow Justice Secretary trained and practised in law, so he should know the importance of consistency when putting a case together. Yet his words today have only brought more confusion to their chaotic approach. First, they accused this government of political interference in this case without evidence. When this was disproven, they argued that we didn't interfere and that we should have interfered in an independent prosecution. So which is it? Mr. Speaker, their approach has only served to distract from their own failings and, frankly, does a disservice to the history and heritage of their party. I respectfully remind the House that part of the reasons we find ourselves in this situation is because the Conservative Party spent their years in government fighting amongst themselves and not fixing glaring holes in our national security laws. The charges in this case were brought under the Official Secrets Act.
Mr Jenrick, when you get a UQ, you get your time, and I want that to be heard in silence, because quite rightly, this is an important issue that affects this House. But I don't need barracking from those benches. I want you to help me, because if you're going to catch my eye in the future, it's not the best way to do so. Solicitor General.
The charges in this case were brought under the Official Secrets Act of 1911, outdated legislation drawn up even before the dawn of World War I. As I said, the Attorney General, the Chief Secretary to the Prime Minister, the Deputy National Security Advisor, the Cabinet Secretary and the Director of Public Prosecutions will all appear before the Joint Committee on National Security Strategy next week. And the Government has committed to fully engaging with committees across both houses as this issue is rightly scrutinised. Along with proper parliamentary scrutiny, another core tenet of our democracy is a prosecution service free of political interference. On this side of this House, this is something that we will always defend.
Mr. Speaker, may I just start by saying nobody in this House is disputing the independence of the prosecution or indeed the judicial officer. Nobody has any dispute on that point at all. The question is a different one. It's whether an official who is giving evidence on behalf of the government, not on behalf of himself, but on behalf of the government, should have had any communication with his own government after the prosecutor said the evidence wasn't sufficient. Now, the argument is that if the government isn't supplying enough evidence, surely it should supply a little bit more. Now, the argument that the government is using is that he gave evidence on the basis of the government between 21 and 23. Well, that's a little odd, because the Labour Party manifesto wasn't written until 24, and yet he quotes it in his evidence. So there is an incoherence here. Either he's giving evidence on the basis of the government's view between 21 and 23, in which case the Labour Party manifesto is irrelevant, or he's reflecting the view of the government post-24, in which case the quotation of the Labour Party manifesto is relevant. Now, which is it?
I thank the honourable member for his question. I think that in terms of the witness statements, to start with, the first and by far the most substantive witness statement was the one that was made under the previous government. In relation to more recent statements, the opposition starting point was that the government in some way interfered with the evidence, and now it seems to be a criticism that we didn't interfere with the evidence. It is right that the Deputy National Security Advisor gave that evidence free from any political interference, as has been confirmed numerous times in this House already.
Sir Ian Duncan-Smith.
Mr. Speaker, my right honourable friend who started this urgent question is quite right, because throughout all of this saga, as my other right honourable friend just made clear, there's been conflicting stories about who did and what was done and why it was done and why it couldn't be done, all in the same breath. But the rules we know require that the Attorney General is consulted in matters that are politically sensitive in this case. It doesn't transgress cut across his independence. It simply means he has to be informed, or she has to be informed, at the time, and it is their role then, if necessary, as we understand from the Director of Public Prosecutions, that they must have been told, the Attorney General must have been told, that there was insufficient evidence to prosecute. If so, the Attorney General's role in this matter, independently, is to say to the authorities in the government, you are not providing sufficient evidence, this prosecution will collapse unless you do. Exactly. Did the Attorney General say to the government, you are not providing enough evidence to secure a prosecution on this? It is over to you to do as you have been asked by the DPP. Did the Attorney General say that to the government? Yeah.
Well, the Attorney General will be giving his evidence to the committee next week. But I think it's right to say that in this case, the case was dropped by the CPS not on public interest grounds, but on evidential grounds. And when a case is dropped on evidential grounds, then the framework sets out that law officers be informed when that has happened, and not that there is consultation beforehand. This was a case that didn't continue on evidential grounds.
Jim Shannon.
Thank you, Mr. Speaker. Can I welcome the Minister to her new role, and to wish her every success and happiness in this role, and hopefully it'll not be as hard the next time round, you know. As the Chinese spy prosecution rolls on, and so too are the growing concerns on the ground about the state of national security and our own intelligence community. So can the Minister accept the lack of confidence that has risen from his handling of the case, and further what can be done to assure British citizens that their interest and security is the top priority for this government, and not trade links with China? Thanks so much.
Here we are. Solicitor General.
Honourable friend, for those kind words. And in relation to the points that he has raised, this case was brought under the Official Secrets Act. There is now new legislation in place, which means that it's no longer necessary to prove the enemy part of the test in order to bring a successful prosecution. That will make it easier to bring prosecutions of this nature in future. It is regretful that the previous government did not bring in this legislation sooner. Had they have done so, I expect we wouldn't have found ourselves in the situation we are in today.